A bank cannot freeze husband's account on wife's complaint amidst a matrimonial dispute. Matrimonial battles can turn ugly, particularly where big money is involved. While women today are largely aware of their legal rights and tactics to extract maximum maintenance or alimony from their estranged husbands, men, on the other hand, remain clueless until they get that first call from the police station. In the current case, the Allahabad High Court ruled that a bank cannot unilaterally freeze a husband's account after receiving a request from the wife while the couple is undergoing marital dispute. What was this case about? The petitioner husband is the director of a company where he owns 41.14% shares, while his estranged wife holds 0.75% shares in the same company. The company is holding a bank account with Kotak Mahindra Bank, which had frozen this account based on a request received from the estranged wife amidst a pending matrimonial dispute. Why did the bank do so? The wife filed a criminal complaint and approached Kotak Mahindra Bank requesting the freezing of this company's account. The bank complied, citing internal disputes, and advised the wife to resolve the matter legally. Subsequently, the wife filed a civil suit to prevent the defreezing of this account. When the husband was unable to access his funds, he challenged the bank's action in the court, arguing that the freezing was arbitrary and in violation of statutory provisions. The petitioner thus approached the Allahabad High Court under Article 226 of the Constitution of India, seeking relief against Kotak Mahindra Bank for freezing its account without any legal authority. According to the arguments placed by the petitioner, the bank had no jurisdiction to interfere in a private dispute and that its action on freezing of accounts violated banking regulations, specifically the conditions under which it was granted a license by the Reserve Bank of India. Now, what were the observations and the order passed by the Allahabad High Court in this matter? The division bench, comprising of Justice Ashwini Kumar Mishra and Justice Arun Kumar Singh Deshwal, observed that the banking operations in India are governed by the RBI Act 1934 and the Banking Regulation Act 1949. Kotak Mahindra Bank, being a scheduled bank under Section 2E of the 1934 Act, is subject to RBI regulations. The High Court then went on to note that under Section 22(3) of the 1949 Act, the banks must meet specific conditions to operate, including the ability to repay depositors in full and maintaining public confidence. The court further added that a bank cannot refuse withdrawal of deposited funds unless permitted by law. When the private bank in question justified its actions by citing a contractual agreement with the account holder, the court emphasized that private banks are not immune from writ jurisdiction when their actions violate statutory obligations. Citing Federal Bank versus Sagar Thomas, the court noted that a writ petition against a private financial institution is maintainable only when statutory violations occur. Accordingly, the Allahabad High Court ruled that Kotak Mahindra Bank's unilateral freezing of the petitioner's account without any legal order violated Section 22(3) of the Banking Regulation Act 1949, and thus the bank was ordered to immediately unfreeze the petitioner's account and allow normal transactions. The court held, so far as the grievance of the respondent wife in respect of a private dispute between her and the director of the petitioner company is concerned, her remedy would be to pursue her grievance either before the competent civil court or before NCLT, where such proceedings are admittedly pending. There are otherwise no requests for stopping withdrawal of the amount in criminal proceedings. The third respondent, that is the wife, therefore would be well advised to seek appropriate direction from the competent forum in accordance with the law. Making request to the bank for freezing the account of the petitioner company would not be the proper remedy. We also hold that the respondent bank has no jurisdiction to entertain the request of the third respondent and thereby freeze the petitioner's account and deny withdrawal of amount from the bank account of the petitioner. You can read this entire Allahabad High Court order in the description link of this video. Keep following us on our social media handles, that is X, Instagram, Facebook and Telegram. The ID is @VoiceForMenIn. You can read several other articles and legal judgments on our website voiceformenindia.com. If you find value in our videos, please consider giving us a like and sharing the same ahead to spread awareness. Lastly, do hit the bell icon and subscribe to our channel Voice for Men India so that you can be regularly updated with new videos. That's it from me as of now. Thank you very much for watching. Namaste. Jai Hind.